I think we're going to get started. We're about 5 minutes late, so we can welcome to this panel. We're very excited to have you all here, touching concerning best practices for litigating the Alien Tort Statute after Kiobel. I'm excited for that. This is Kimberly. We organize this panel, and I think Kimberly will introduce our moderator.
So our moderator today is Professor Jeena Martinez. She's the Warren Christopher Professor in the Practice of International Law and Diplomacy here at Stanford. Professor Martinez is a leading expert on international courts and tribunals, international human rights, national security, constitutional law, and the laws of war. Her research focuses on the role of courts and tribunals in advancing and protecting human rights, ranging from her work on the all-but-forgotten 19th century international tribunals involved in the suppression of the transatlantic slave trade through her work in contemporary institutions, like the International Criminal Court and the role of courts in policing human rights abuses in connection with anti-terrorism policy. She was also an associate legal officer for Judge Patricia Wald of the United Nations International Criminal Tribunal for the former Yugoslavia in The Hague, where she worked on trials involving genocide, crimes against humanity, and war crimes. Professor Martinez has also worked on numerous cases in the U.S. Supreme Court and the Courts of Appeals involving international law and constitutional law issues, including cases involving the Alien Tort Statute, which we're talking about today, the Torture Victims Protection Act, and the detention and trial of post-9/11 detainees. So please welcome Professor Martinez, who will introduce the rest of our panelists as well.
I'd like to thank very much our panel members for joining us on such a beautiful fall Saturday afternoon to sit in this dark classroom and talk about legal issues. I'm just going to briefly introduce the panel. You've got bios here, and since we only have an hour, I'm not going to read their bios. I'll just briefly mention we have first Kristin Linsley Myles, who's a partner at Munger. Kathy Roberts, who's the legal director for the Center for Justice and Accountability, and Jeena, Shah, who is an attorney at the Center for Constitutional Rights. And their full bios with all their impressive accomplishments are here. The organizers asked me to briefly describe the Alien Tort Statute. I assume that most people who've decided to come to this panel have probably heard of it before. But in case some are just at the conference and don't know a lot about it, the Alien Tort Statute was a federal statute that was part of the first Judiciary Act in 1789, and it provides somewhat critically that the federal courts have jurisdiction for suits by aliens for torts in violation of the law of nations. And this curious statute that was in the first Judiciary Act was not much used, a couple of times only, until the 1980s. When the sort of modern era of ATS litigation began with a case called Villartiga that was brought in New York City, and that was a suit by relatives of an individual who had been tortured and killed while in government custody in Paraguay. And the Second Circuit in that case held that the torturer, like the pirate and slave trader before him, had become an enemy of all mankind, and that individuals were susceptible to suit under the Alien Tort Statute in U.S. court in cases where they were subject to personal jurisdiction. In that case, the alleged torturer was physically present in the United States and had been spotted by the relatives of the deceased. And so they knew, they found him, and he was brought to court. Following that, there were a number of cases over the next decades. Groups like the Center for Justice and Accountability began operating, and a lot of those early cases were quite similar, in fact, to the Villartiga litigation in the sense that they involved suits against individual perpetrators who had been found in the U.S. So generals from various parts of the world who'd been in military dictatorships, tortured, killed people, etc., and had come to the United States and were living when they were served with process. A few cases also of foreign leaders who were served with process while visiting in the United States. Then began some new sort of uses of the Alien Tort Statute that lead us to some of the topics for today, which was the increasing use of the statute against corporations for alleged human rights abuses and for aiding and abetting human rights abuses of governments in countries when they were operating. And this began a little more than a decade ago to come to quite prominent attention. The Supreme Court heard the first Alien Tort Statute case that it considered in 2004, which was a case called Sosa. This was an individual case, not a corporate case. But in that case, the Supreme Court did hold that the Alien Tort Statute did allow the federal courts, under their federal common law powers, in the use of their jurisdiction, to recognize causes of action for suits in violation of the law of nations. And so there had been quite a bit of controversy before the Sosa decision as to whether the ATS allowed human rights lawsuits in U.S. court at all. And the majority of the court in 2004 in Sosa held that it did. The Kiobel case was decided by the Supreme Court a little more than a year or so ago. It involved claims by plaintiffs who had received political asylum here in the U.S. That is, they were immigrants to the U.S. who had asylum based on their well-founded fear of persecution in their home country. And the Kiobel case involved allegations that Shell Oil had aided and abetted human rights abuses by the government of Nigeria in connection with the Nigerian government's actions against the Ogoni people, the indigenous group that had organized to protest Shell's extraction operations in that region. The case went up and down the court several times. In an earlier stage of the litigation, the U.S. Court of Appeals for the Second Circuit held that suits against corporations were not cognizable under the Alien Tort Statute because, in the reasoning of the Second Circuit, international human rights law applied to governments and to individual human beings, but not to corporations. That is, it did not impose duties on corporations that were cognizable in a court of law under the Alien Tort Statute. The Supreme Court granted review on that question of whether corporations were susceptible to suit under the Alien Tort Statute. But at the oral argument for Kiobel the first time around in 2012, the justices raised an oral argument, a question that had been considered in some of the amicus briefs with respect to the application of the Alien Tort Statute to conduct occurring outside the territory of the United States. As some of you will know, there is in general a presumption in U.S. statutory law against the extraterritorial application of statutes. It comes from a case called the American Banana versus United Fruit, which was a decision by Justice Oliver Wendell Holmes in 1907 or so. The argument was made on re-argument in Kiobel that this presumption should be used in the context of the ATS, and the ATS shouldn't apply to conduct that occurred in the territory of a foreign sovereign, that is in Nigeria in that case. The Supreme Court agreed with Shell Oil that the ATS was in fact limited, not strictly speaking by the presumption against extraterritoriality, because the odd fact that the ATS is a jurisdictional statute, but the court said that in the recognition in their common law powers of causes of action under the ATS, the federal court should be guided by that same presumption that ordinarily operates in the statutory context. For cases that do not touch and concern the United States. And one of the questions which the panelists will no doubt talk about in detail is what exactly the court meant by touch and concern the territory of the United States. The Kiobel case itself was what some observers have called a foreign cubed case. That is, it involved foreign national plaintiffs, although resident in the United States, suing foreign corporations. The defendant corporations there were British and Dutch companies, as well as the Nigerian subsidiary, concerning conduct that occurred in the territory of a foreign state. What cases might touch and concern the United States territory with sufficient force to displace the presumption against extraterritoriality, the court did not answer. And the lower courts, as we'll hear, have been addressing that issue in a variety of cases. But most observers agree that Kiobel altered the litigation landscape for Alien Tort Statute cases. And so with that, I will turn it over to the panelists. And I'll briefly mention that there is another statute, the Torture Victim Protection Act, which was enacted by Congress in 1991, which extends a cause of action to people, including U.S. citizens, for torture and extrajudicial killing. And it was an amendment to the provision that includes the Alien Tort Statute And the TVPA has a sort of separate statutory basis, and is another ground of litigation. With that, I'll turn it over to Kathy to give us a little bit more background.
Thank you. So when I was in Somalia last March, one of my clients, Farhan, asked me to meet with his eldest children, his eldest son and eldest daughter. So we met, we got some fruit juice and some tea, and we sat and we chatted for a while and got to know each other a bit. And when we heard the call to prayer, Farhan got up. He stood up, he said, "I'm going to go pray, and I'd like you to explain to my kids what happened to me and about our case." And he walked away. So I had this tremendous privilege and responsibility to explain to his children about how their father had been arrested because of his Klan background, tortured for weeks, shot 5 times at point-blank range, and left for dead, how he had miraculously survived, and upon discovering that the man who shot him and who had command over the people who arrested and tortured him was living in the United States, sought public justice in court rather than private revenge. So as Jenny noted, I'm Kathy. I'm the legal director at the Center for Justice and Accountability, or CJA, and I think I was invited to join this panel to give a little bit of perspective from those individual defendant cases that are like the Florida style cases. CJA specializes in cases against individual defendants. Paul Hoffman sends his apologies. I spoke with him a little bit, and I'm going to sort of bring in the Paul piece to talk a little bit about the sort of landscape in the circuit courts regarding corporate accountability. But I think even before I put on that little technician's hat and talk to you about these specific strategies and issues, I really hope that from this panel you will see what is just an example of a way of using the law as a tool to advocate for justice and for human rights. And the ATS has been, for the last many years, a wonderful tool, but it isn't the only possible tool, and I hope that with your brilliant minds and legal educations that you will perhaps discover better tools, create better tools, or find better ways to use them. And this would be just an example, just our meager contribution to that ongoing movement. So putting the technician's hat on now, I want to talk about 3 things. I want to talk about the chaos in the courts that has fallen in the wake of the Kiobel decision. I want to point out some strategies for litigating, particularly in the context of multinational corporations using the ATS, and sort of how we can try to keep human rights litigation alive. And third, I want to worry aloud with you about some other threats that I see on the horizon that are maybe more visible from the perspective of the individual defendant cases, but which are quite important. So first of all, chaos in the courts. Well, maybe it's not entirely chaotic, but the majority opinion in Kiobel is very hard to interpret, and the 3 concurring opinions are not consistent with each other in harmony, to say the least. The result is that the courts are coming up with decisions that are very much across the board. Litigants, all of us, when we file a case, or as we defend our cases that have already been filed, we don't really know whether the ATS claims are going to survive. And not just because we think maybe there's like a little issue here, a little issue there, but because we actually really, I think, even up to now, don't really know what Kiobel means for human rights litigation. So, give you Paul's bit. I'm not going to read you this whole thing, but I want to be sure I represent it correctly. So for those of you who are playing at home, now is the time to pull out your scorecard. You've got 11 circuits. There's 4 that are really in play. They'll really give you the lay of the land. The 4th Circuit, Al-Shamari versus Kathy, which was litigated by CCR, where Jeena's coming from. That's our best case in that for the plaintiff side. That case, the 4th Circuit held that Kiobel means you have to determine whether or not the claims, as opposed to the conduct, touch and concern the United States with sufficient force. And you look at the identity of the parties, you look at U.S. national interest, you look at availability of alternative fora. So it's a very fact-intensive kind of analysis. The 9th Circuit, Doe versus Nestle, hasn't given us a clear decision of what it means yet, but they've essentially remanded that case to allow the plaintiffs to plead additional facts that would show that they have overcome the Kiobel presumption, which suggests that they're going to find something other than a clear cutoff. That's our second best case. The 2nd Circuit, Valentulo versus Daimler. was one of the first decisions, maybe the first decision to come out of a circuit court on Kiobel, and that decision doesn't require that the torture or whatever you've alleged happened on U.S. soil, but it almost does. It seems to allow just a little bit of room for some kind of a case, but it's a little bit unclear. Some kind of U.S. conduct is going to be required, maybe not, or maybe what the Alito concurrence suggests, which is that the actual human rights violation had to happen within the territory of the U.S. The 11th Circuit, very recently, in the Chiquita cases, basically held that position, that you have to have your torture, your extrajudicial killing, or your crimes against humanity have to have happened in the U.S. in order to surpass the Kiobel presumption. So that's kind of as far a range as you could have. I will quickly note that there's only one individual defendant decision so far, and that's in the Second Circuit. It follows Valentulo. It dismissed all the ATS claims against an individual corporate officer. The TVPA claims against him were allowed to proceed. So this is all stuff that should inform our future discussion. Oh, I did have some numbers I wanted to give you. In pure numbers, plaintiffs are not doing well. And by my count, and I'm pulling out 21 frivolous suits by one person because I think it distorts. So not counting those 21 cases, I think we have 47 decisions on Kiobel so far. 5 ATS cases have been found to meet Kiobel's requirements. Only one at the circuit level, that would be the Al-Shamari case. The other 4 are individual defendant cases, which is interesting. What I think you'll find, especially in light of that Second Circuit decision, is that the individual defendant cases and the corporate cases are largely in the same boat, because it's very difficult to come up with any kind of principle, perhaps impossible, to come up with a principled distinction between an individual foreign accused case and a corporate foreign accused case, to use that language, which I actually try not to use. So that was a bit of a very brief overview. I can tell you that in the Fourth Circuit, we don't think that there's any appeal happening. We think that the defendants are seeking, as the Al-Shamari case, are going to try to go for another bite at the apple with the district court, try to get a political question, get it knocked out that way. There's, repleading is going on in the Ninth Circuit. Repleading happened in the Second Circuit, and they were dismissed, and they're going up again. So we'll find out really what that decision means, although we're not hopeful. And I think the plaintiffs in the 11th Circuit case and the Chiquita cases, at least some of them, which means effectively all of them, will be appealing to the Supreme Court. And it may be the strongest set of facts to go to the Supreme Court, because this is a corporation that was already criminally convicted for supporting the paramilitary forces in Colombia. So there would seem to be some U.S. interest in that conduct related to a civil case. So we can discuss that further. But my second message is fight like hell and reach for alternatives. We should not give up on the ATS, since at least under some interpretations, there's still an avenue for advocating for human rights here, although a somewhat more limited one than we had before. At the same time, maybe we shouldn't put all our eggs in the same ATS basket. So repleading, arguing every possible fact that you have that could connect your case to the U.S., U.S. interests, etc. Push the standard to define, push the courts to define that standard in a way that's most useful. I think that's what we're all working on. Milk the concurrences, push the factual distinctions, and appeal strategically. Maybe this is obvious. But I would say also look at alternative statutes, such as the Torture Victim Protection Act, which we do in our cases, in CJA's cases. This would allow us then to add pending claims based on state law, or based on, depending on the choice of law in your state, based on the law of the foreign country, or the country where the abuses took place. Corporate cases, if they have some kind of federal law they can tack onto, they could do that, or they could just file straight in state court. Nothing stops anybody from filing straight in state court, and you can imagine a patchwork of 50 different bodies of law on international criminal law in all the different states. Actually more than that, because many states then would choose choice of law, and they would be litigating over what Somali law is, or what Colombian law is in Florida, for example. So, how this played out in Farhan's case is, initially, our ATS claims were dismissed. We weren't allowed to brief it, we weren't allowed to argue it, it's dismissed. We're going up to the Fourth Circuit. I'm somewhat hopeful. I think because Al-Shamari versus Kaki is a standard that I think allows room for our case, but we'll see, because I don't know. I certainly know what arguments I will make, right? But at the same time, this leads me into talking about some of my worries. The defendant's also appealing because the court did not dismiss our suit based on a claim of immunity. And you should know, while the plaintiffs try to decide whether or not they're going to appeal the Chiquita case to the Supreme Court on Kiobel, there's already a pending petition at the Supreme Court in the Samantar case on immunity. So you could see, one can imagine, I'm going to paint a very dark picture here, and I don't want to give you no hope, because I think this is just the way it goes. Human rights litigation is always a bit uncertain. But one can easily imagine Kiobel, Cabin's ATS claims to the United States, making it effectively useless for most of our claims, or just redundant with civil rights law that exists. The TVPA could be knocked out for all foreign official cases, right? Because if we end up getting immunity for individual officials of foreign governments, I mean, it reverses Nuremberg, but it is the argument that's being taken up at the Supreme Court and appears to have some traction. Then all you have left would be TVPA cases against corporate officers or non-government individual private officials, such as paramilitary actors. How long will that last? I think that you would see an attack against color of law. And in one of our cases in the Southern District of Florida, we had our ATS claims knocked out, and then, relatedly, I would argue, one of the TVPA cases was knocked out because Columbia, color of law, it's a very politically fraught situation. We had shored up, we think we have absolutely the facts that we're repleading, and hopefully we'll convince the judge, but we knew that a lot of cases had gone against plaintiffs on color of law, so we were like, well, we have war crimes, and you know, we can absolutely get it with war crimes. We don't need color of law. We lost the war crimes with the ATS, leaving us with only the TVPA. So you see how these things are connected. So it's a worry that I have. So my closing thought would be this: don't panic. Just over 10 years ago, when Sousa was headed to the Supreme Court, a lot of us thought human rights litigation under the ATS was over. When that was that case, many people forget, we lost that case, right? That particular plaintiff lost, and yet the decision resulted in, I think, really, ultimately a very nice result for human rights litigation, because we got some agreed standards that allowed the courts to determine what claims could go forward and which ones could not, and you can see how human rights litigation was able to flourish in the post-Sousa regime in a way that I think is very fair. So we're in a similar place right now with Kiobel. We don't know what's going to happen. When I spoke with Farhan's kids, after I told them about what happened to him and told them a little bit about these cases, we didn't have a long discussion of Kiobel, but the son said, you know, I don't know, I kind of feel like maybe we should be seeking revenge for what happened to Dad. And the daughter said, no, Dad's got the right idea. We should be going to court. People should know what happened. That, I would submit to you, is what's at stake with human rights litigation and whether or not we can allow it to go forward or find a way for it to go forward. As I said before, the ATS is just one tool. I hope you can figure out some really cool additional tools or ways to use them, because I do.
Thank you, Kathy. We'll turn now to Kristin, who I think will have a very different perspective on whether the law has gotten to a good place now and whether the courts have gotten it right or wrong so far.
Okay, great. Let me just start off with a couple of disclosures. Kathy mentioned the Doe versus Nestle case, which I and my firm are litigating right now on behalf of Archer Daniels Midland. That case is brought against Archer Daniels and Nestle and Cargill in connection with cocoa bean harvesting in West Africa. I can talk about the facts of the case, but just that was in the interest of full disclosure. And yesterday we filed our petition for rehearing from the decision that Kathy was just describing. So we'll see where that goes. I even asked Paul Hoffman if that's why he wasn't here, and he said no. He had something else that came up at the last minute. Paul and I have been litigating each other for I don't know how long, since the Unical case that he and a number of other people filed back in, I think it was like 1996 is my guess. in that vicinity anyway, so we litigated that one as well. We also put in a couple of briefs in Kiobel. In both rounds of Kiobel, we put in amicus briefs. So anyway, I thought it was worthwhile just talking a bit about the Kiobel decision itself and a little bit of background leading up to it. Just kind of really skimming the surface on what sort of was behind what was the law leading up to Kiobel, essentially. Because sometimes you have to think about how international law works, and people have very different conceptions of how it works, and so sometimes, you know, you have to kind of set the stage and get into a mindset. The ATS incorporates the law of nations. It says a tort only in violation, committed in violation of the law of nations. And so it kind of forces you immediately to figure out, well, what role does international law play in figuring out how to apply this statute? The court said in Sosa that it's just jurisdictional. It doesn't create a cause of action under international law. It doesn't create a cause of action. But Sosa said, and Sosa, Justice Souter, I'm sure you guys have all read Sosa anyway, but an excellent, really well-written decision, very thoughtful. I'm not sure he had in mind in writing it sort of where it would go and how every little passage in there would be read, both to favor and to be against the use of the ATS. I think both sides claimed victory from that decision, because on the one hand, he went into like at least 7 or 8 reasons why this limited power that the court recognized to incorporate common law conceptions of international law must be exercised cautiously, because it's an essentially legislative exercise. On the other hand, he left the door open, the court left the door open for the use of the statute in that way. And specifically, although it doesn't create a cause of action, it recognizes that the statute wasn't meant to be, was meant to have some application the moment it was passed. It recognized that there were some principles of international law out there that were so well recognized that they would have been thought at the time, in 1789 when the statute was passed, to be immediately actionable and to give rise to a right to relief. And the 3 that were most close at hand, because they're mentioned in Blackstone, were piracy, violation of the right of safe conduct, in other words, passage from across the borders from through a country, and the right of ambassadors to be free from torts and other things while they're on the local territory. So those were the 3, examples of international law that would be immediately actionable under the social court's view. And then the court said, and there may be others out there that are as well established as those, as the 18th century analogs, that would have to be equivalent in their universality and in their the quality of their being mandatory, universal, and obligatory. Those are the 3 sort of touchstones of international law that makes something, if agreed upon by most nations, to be actionable in international law. So that's kind of a little mini primer, because it kind of gets you into extraterritoriality. Going into Kiobel, there's been a long-standing international law doctrines of extraterritoriality. 2 doctrines, really, it breaks down into 2 big pieces. One is international law generally says that a nation has jurisdiction within its own borders and not outside its borders. That's sort of an international law limitation on a nation's power. Somewhat self-imposed, but if all nations agree on that limitation, it becomes a principle of international law, extraterritoriality. The exception to which is, the biggest exception is that any nation can control its own citizens no matter where they are, including corporate citizens, individual citizens, etc. So it's kind of this odd combination of what's called the principle of nationality and the principle of extraterritoriality. Now, so that actually was briefed in Kiobel. That was one of the amicus briefs that I think it was Jenny mentioned that triggered, I think, the court's extraterritoriality inquiry. a brief written by Jack Goldsmith at Harvard on behalf of Chevron and some other entities. It's an excellent brief, and he argued that the use of the ATS in the way it's been used violated international law, violated the principle of extraterritoriality. The other principle, which was also briefed during the first round of Kiobel, is the principle of presumption against extraterritoriality. The presumption is an entirely domestic creature. That's an entirely U.S. created doctrine, which said, we the courts, because Congress is the one, this is also echoed in SOSA, Congress is the one that is to decide how our laws apply, including whether they apply, whether the nation will purport to reach out beyond our boundaries or not. We, the Supreme Court and other courts, will assume that Congress did not need to do that. So when we construe a domestic statute, we will say, we will understand it to apply only domestically unless it's very specific in reaching beyond our boundaries, at which point then its constitutionality or its validity as a matter of international law is something that would need to be dealt with. But Congress is the one that's going to decide that. Are we going to purport to reach beyond our boundaries? And that presumption actually applies whether it's a domestic entity or not. It applies, period. So if a citizen of the United States is doing something overseas and someone invokes a U.S. statute, it doesn't matter that they're a citizen of the United States under this doctrine. The presumption says it doesn't apply to overseas conduct. So that's where Kiobel was. Kiobel went down the path of adopting the presumption. But then in the final paragraph of Kiobel, it kind of threw it open to sort of like, what does that mean? The court said that the presumption applies. There's no exception because it's kind of a jurisdictional statute, not a real statute or not a substantive statute. No exception for that. The court went through the history, the text, numerous arguments made in favor of saying why. Oh, I meant to mention, courts will presume that it doesn't apply extraterritorially unless there's a clear indication from Congress in the text, the history, or something else. So the court went through all those things. Text, history, didn't find there to be any clear indication that Congress meant it to apply to overseas conduct, found the presumption applied, and found, therefore, that the statute didn't apply extraterritorially. Then the court said, in a final section of the opinion, on these facts, all the relevant conduct, in that case, it was a foreign company, foreign conduct, foreign plaintiffs, took place outside of the United States. And then the court said, and this is the passage that everybody's now debating, and even where the claims touch and concern the territory of the United States, which of course they didn't in Kiobel, even when they touch and concern the territory of the United States, they must do so with sufficient force to displace the presumption against extraterritorial application. See Morrison, 561 U.S., slip out 17 to 24. Okay, so then you say, okay, what the heck does that mean? First of all, the court just said the presumption applies, so why is it talking about now displacing the presumption? That makes no sense. The court said there's a presumption, it applies, it hasn't been overcome, but so that's problematic use of the word presumption, but nonetheless, the court says touch and concern. The court doesn't say when something touches and concerns the United States, then it automatically applies even though the conduct takes place somewhere else. The court doesn't say that at all. The court doesn't say that it doesn't apply extraterritorially except when it touches and concerns the United States. The court simply said, even where the claims touch and concern the territory of the United States, they must do so with sufficient force to displace the presumption. Okay, then you say, well, what's Morrison 561 U.S. slip out by 17 to 24? Well, if you go to that, it's section 4 of the court's decision in Morrison. Section 4 of that decision talks about, in Morrison, it had to do with whether the Securities Act of 1930, the Securities Exchange Act of 1934 applied to fraud that took place in the United States, but the securities were traded on foreign exchange. The court said the statute didn't apply to that because it doesn't apply extraterritorially, and there was no indication Congress meant it to. Then they had section 4, which says, well, what does it mean to say whether it applies extraterritorially or not? If it's domestic, then it's covered by the statute. If it's not domestic, if it's extraterritorial, it's not. So here's section 4 of Morrison, which says here's how you figure that out. And there have been all sorts of tests that were tried out, center of gravity, where's most of the activity, et cetera, et cetera. But the court said none of those are good. The court said that what we're going to say is what was the focus of the statute? And if the conduct that is the focus of the statute occurred overseas, it's barred. That means it's extraterritorial. That means it's covered by parts 1 through 3. So, what's the focus of the Securities Act of 1934? The court said it's the exchanges. That's what it's all about. The entire statute is about creating the securities exchanges on which we're going to trade shares. And the anti-fraud provisions of 10b-5 come out of that. So even though the fraud took place in the United States, even though the defendants were United States companies, it didn't matter because the exchange was overseas. Okay, that's the test that Kiobel incorporated into itself when it said in part 4, okay, what does, if the claims touch or concern the territory of the U.S., as they obviously did in Morrison, they must do so with sufficient force to displace the presumption against extraterritorial application, see Morrison. Okay, so then you say, okay, what was the focus? So then you say, well, first of all, why did the court do it that way? Who knows? There were 5 people, they need to get 5 votes. If you read Kennedy's opinion, maybe he wanted to keep it a little murky. But nonetheless, if you really scrutinize that paragraph, it's pretty clear they're incorporating part 4 of Morrison. So they didn't do it with words, but they did it with the pretty clear citation to that entire section of the Morrison opinion. But what does it mean? And so that is kind of how it's been playing out in the courts of appeals. I think as already has been recited, there's different ways that the courts have gone. The 11th Circuit is probably the one that is the 11th Circuit has addressed this particular issue most directly. And in our case, Archer, Daniels, Nestle, Cargill, Doe versus Nestle it's called, it was addressed, but mostly in a separate opinion, just really a dissent from the way they had handled the case. In our case, the court said Morrison doesn't really apply. And then the dissent said, well, why did they cite it then and incorporate the provision that I just was talking about? So that's sort of where we are in our case. And then in the other cases, it hasn't really been mentioned, and people have fixated on the words touch and concern to say that's the test, that's the new test. So as long as it touches and concerns the United States, you're good. And of course, that could mean anything. And one of the things that gets argued is domestic defendants. Oh, well, Shah was a foreign defendant. What about domestic defendants? That touches and concerns the United States. They're in the United States. But it doesn't really fit because that was the whole presumption against extraterritoriality. The presumption has consistently said it applies whether the defendant is domestic or foreign. It doesn't matter. It's where the conduct happened. Like, for example, there's a lot of labor cases that were decided before Morrison, and those had to do with if you're a U.S. company operating in France, what labor law applies? Does the Fair Standards, whatever it's called, Fair Labor FLSA, does that apply? Does that apply in France to the United States employees or United States companies? Answer no, it doesn't. The court said no, because that's overseas, and overseas, the U.S. labor laws are presumed not to apply. Now, if Congress said this law applies to all U.S. corporations doing business overseas, it would apply. Because nothing in international law would prevent that. That would be perfectly fine, but that's the court said Congress didn't do that. So the same rule really should apply in this context, but let me just mention a couple other things. Because I'm more just talking about how Kiobel gets interpreted and how one might interpret it. But what does it mean, and kind of how does it apply now? How does the world of international law work under this conception? If that is what Kiobel means, for example, putting aside the whole netherworld of what touch and concern means, what focus means, etc. Generally speaking, it goes back to more a world in which. And I don't think this is a world that didn't already exist, because it really is very debated in the international community. what is the substance of international law? How broad is international law? What does it mean to be international law? Does that mean it trumps domestic law? Or is it kind of just a conglomeration of all the domestic law that reflects the international consensus on this particular issue? So that, I don't know that there's an agreement among international scholars on that. But often how it works is that the nations agree, either because their decisions all come out the same, their legislatures all pass laws, etc. It becomes such a universally agreed upon principle that somehow it gets elevated to a principle of international law. Or it's done by treaty, or by treaties among lots of nations, or by conventions, or by other international law activities that are designed to come together and gather and reflect the consensus of nations. So those are, again, you could have many, many years of lectures on this exact subject, so I'm just skimming the surface here. But one commonality to that model is that sometimes what happens is the nations agree. This happened in the Torture Convention and other similar conventions on similar topics. Here's the principle: no nation shall do this. And each nation is obliged to bring that down into their domestic law. So they are obliged to create legislation domestically to put that international agreed upon principle into effect at the domestic level. That is, I believe, how the Torture Victim Protection Act came about in the first place, because it was not only an embodiment of the rule that had been articulated in Philartica as a matter of international, essentially common law, but it also had been the subject of the International Convention on Torture, which required, as one of its provisions, that each nation that was a party to the treaty enact domestic legislation. So, to use an example, so this is one thing that happens if you have a world of Kiobel. Okay, Kiobel says the United States courts can't say, here's what we think international law is, and now we're going to say this version of our version of international law, whatever we say, we interpret it to mean, applies to conduct no matter where else it happens in the world. We're just going to apply our version of whatever we think, say, inhumane conduct is. We say that's actionable, and we say here's what it means to activities occurring in other countries. Rather than that model, you have a model that says, here's the nations get together and agree, here's what we think it means in each nation, then the model would be, it incorporates that into their domestic legislation. Now, an example of where that's actually worked, because I think you can make a lot of arguments on contexts in which it would be difficult for that actually to be effective, is in the labor area. And this sort of gets to issues of corporate accountability as well. I'm being told to run out of time, but it's International Labor Organization creates these conventions on Convention on Slavery, Convention on Forced Labor, Convention on Child Forced Labor, Convention on Child Labor, etc. But the conventions are meant to apply. Each member nation, and most nations of the world are members of the International Labor Organization, commits to enact domestic legislation embodying those conventions. And then the ILO, which is a division of the United Nations, makes sure they do it. Make sure that each nation does it, and that each nation enforces those laws effectively. So it's a model, that I think you can come away, putting aside, I think Kathy's done a great job on what one can do as litigators and as advocates, but also just as an international law model that could work. I think that's a model that after Kiobel and reconceptualizing international law in domestic application, one could strive to make that type of model work. So.
Thank you very much. We'll turn to Jeena.
Sure. So I'm going to talk a little bit mostly on the Alshamari decision that Kathy referred to. But before I go there, I want to just take a step back and think about our role as human rights advocates from the U.S. side. And looking back at history where we started talking about human rights as opposed to civil rights. And we see that it started with abolitionists, and then it moved on to later racial justice radicals like Malcolm X, who are all basically saying that if the law in your own country is actually legalizing systematic oppression and violence against a group of people, we need to go beyond that law. we need to think about human rights that are held by us all. And that is really the history that we're coming from, and that was translated into litigation starting from back in the 1940s and 50s. ATS scholar Beth Stevens has pointed out that in litigation challenging discriminatory laws against Japanese immigrants, international human rights norms, which were very new at the time, were being drawn into that litigation, were actually used by judges in their opinions. And I say all this because I think that we have, as human rights advocates, we do have a very sort of grim view on the future of ATS litigation and human rights litigation after Kiobel, but I also think, because I like seeing opportunities when I'm presented with challenges, I also think that it presents us with an opportunity to go back to our roots of human rights, coming from the US, coming from a settler colonial state, coming from a state that has actually, in the present day, has through neo forms of colonization caused so many human rights violations of the world. This idea that we need to touch and concern the United States can bring us back to fighting American exceptionalism. This idea that America can talk about human rights, but we don't need to practice them. And if it can draw us back to that, there's still a lot of work to be done, right? So there's still, when we think about US human rights violations around the world, we think about the State Department, we think about the military, we think about CIA, we think about corporations, we think about individuals. There is a ton of work to do. So there's still a lot of opportunities for us to be focusing on bringing justice into this world. I also just want to add that, the civil rights movement in the US, litigation-wise, has seen so many obstacles like this come into play, from false qualified immunity to Bivens special factors, and, they've all just sort of, trumped up the bar to actually bring successful civil rights litigation, but that hasn't stopped it at all. What it has done is it has made us realize that the law is not going to change anything. The master's tools are never going to dismantle the master's house. But we can continue to find new ways to use it creatively, as Kathy was talking about, in order to fight for justice. And so I say all that because, I think that the Al-Shamari case, was a real great example of the court seeing a set of facts that are probably one of the most glaring examples of American exceptionalism in our time to survive Kiobel, and that's the Abu Ghraib torture scandal in 2004. 2004. So the case is Al-Shamari versus Khaki. It was brought elsewhere, but it's currently in the Eastern District of Virginia. Khaki was a private contractor that was hired by the U.S. military to provide interrogation services at detention centers in Iraq. It was the only private company to provide interrogation services in Abu Ghraib. And what we later learned through military investigations and through court-martial proceedings was that there was a command vacuum that existed in the prison, and Khaki interrogators exploited that command vacuum. At night in the prison, Khaki interrogators instructed low-level military police officers to quote-unquote soften up detainees for interrogation, which was understood as code for techniques that amount to torture and cruel, inhuman, and degrading treatment. While low-level police officers, after the pictures came out, Seymour Hersh had his New Yorker article, and we all learned about what was happening in Abu Ghraib, and then we later learned what was happening in many other places in Iraq and elsewhere. The low-level police officers, to sort of appease the public, both in the U.S. and abroad, were court-martialed, were convicted, and were sentenced. But no high-level military officials who abdicated their responsibilities in the prison, no private contractors who played a key role in the abuses, ever faced any threat of criminal sanction. So Khaki earned millions of dollars in that government contract, and despite the fact that its employees ordered a lot of the torture, despite the fact that the corporate headquarters had knowledge of it and encouraged it by promoting interrogators involved in the abuse, it continued to earn money off that contract. To this day, it earns billions of dollars in U.S. government contracts through its work for DHS. So the case, the initial part of this case, it was initially filed in 2004 as a class action. It didn't get certified. It broke off into smaller cases. The current case was filed in 2008. We've been up and down the district court and the appellate court for several years. And then following Kiobel, the judge asked us to to talk about how Kiobel does not actually preclude our case. We had lost at the district level, and we appealed it last summer before the Court of Appeals, or I guess last fall. And we basically argued that, I think as Kristin laid out, in order to understand Kiobel, we need to understand Morrison. And I think, there's, up to a certain extent, I think Kristin and I are on the same page, and then you'll see how our paths diverge. So, yes, we need to look at Part 4 of Morrison. And in Morrison, the Supreme Court had decided that as a threshold matter, the presumption against extraterritorial application of laws applies to Section 10b of the Exchange Act. The court then explained that, as has done before with other presumptions, with other canons of statutory construction, this is nothing new. You first have to determine whether or not the facts of the case trigger the presumption in the first place. And that's not as obvious as it seems. And so, in order to determine that, because there's so many facts at play, and this day and age, you always have facts like crossing borders. But so how do you determine whether or not the presumption is even triggered? Morrison says you look at the focus of the statute. So the focus of the statute is deception in connection with sales and purchases of securities. There, the plaintiffs had argued, it's U.S.-based. The deception, the fraud, it had to do with the mortgage crisis. The fraud actually occurred in Florida. So the fraud around the securities had been, this false statements had been made in Florida. The securities that were related to those false statements were foreign securities. They were on an exchange, I think, in Australia. And the court said, actually, the focus of the statute, as Kristin was explaining, is not the fraud, but on the sales and purchases of securities. So there we had the sales and purchases of foreign securities on a foreign exchange. So the court said, if we look at the focus of the statute, that this fails. This is under, in securities language, this is a foreign cubed case, and so it's precluded. But like Kiobel, it left it to lower courts to determine what actually falls within the focus of the Morrison statute, what facts fall within that. And lower courts, primarily the Second Circuit, because that's where a lot of securities litigation happens, had to develop sort of factors or tests to determine whether or not facts are territorial or extraterritorial. And they basically, I think different district courts have described it differently, but it's basically, is it a foreign, it doesn't matter where this deception has occurred, but is it a foreign transaction of domestic security or a domestic transaction of a foreign security? And that's how they determine whether or not it falls whether or not it even triggers the presumption. So now if we take that to Kiobel, we see that in Kiobel, the justices spent a long time talking about the focus of the ATS. We go back into history and we go back into those incidents, in the 18th and early 19th century when, this was still something that people were talking about, and we look at the examples that were given, and it's just when it's a tort against an ambassador who was visiting the United States, or, it was incidents where the U.S. could be embarrassed by not providing civil remedy. And so it's this idea of, when you think about the law of nations, why did the U.S. at that time, why to this day does the U.S. care about the violations of the law of nations? It's because, purportedly we want to live in harmony with this community of nations. And if the United States is seen as responsible for remediating a violation, then it must do so to avoid diplomatic strife. And that's what we see, and when you pull together the historical context that the justices pull together, that's what you see as the focus of the ATS, where the United States would be seen as responsible for remediation to avoid diplomatic strife. That is the focus. That's why courts are given jurisdiction to hear those kinds of cases. And then, like Morrison, it left it to lower courts to determine what facts fall into that focus. And that's where we are today. We have courts that have take the Alito concurrence and see it as the only facts that matter, the facts that actually is the conduct that amounts to the violation of the law of nations. If that were the case, they wouldn't have needed to write a separate concurrence. Then you see others who are saying, well, okay, it is facts specific, and there's a constellation of facts that could make the U.S. responsible. And in Alshamar, we had there was ever a constellation of facts, we had them in Schonbrun. So we had U.S. corporate defendant that sent U.S. citizen employees to Iraq to work in a U.S. base to interrogate detainees held by the U.S. government. They worked in concert with U.S. military personnel via a U.S. government contract, and they were supported by U.S.-based corporate conduct, which is knowledge of the abuses, promotions, lack of supervision, so they were supported by that connection to the U.S. And so if you look at those facts together, it's clear, and it has been clear since the day those photos came out, that the international community would see the U.S. government as responsible for remediating this violation of law of nations. So the Fourth Circuit, very fortunately, agreed with us, but it was clear, it made clear that when it was saying that our claim survived Kiobel, it was really making its ruling to our case, because it was saying that there might be other facts. There could be lesser facts. There might be other facts that meet this, but we don't need to decide that. We just need to decide the facts of our case. And what's interesting is the reasoning that the court focused on. So the court focused on the fact, as Kathy had pointed out, that it's not just conduct. The Supreme Court, the majority opinion, had specifically said whether claims touch and concern the territory of the United States, and claims includes not only conduct, but the parties' identities and their connection to the causes of action. Second, the court said that the purpose of the presumption itself is to avoid international discord and, quote, unwarranted judicial interference in the conduct of foreign policy. And the court interestingly focused on how one of the reasons why you would avoid international discord here is because the plaintiffs are seeking to enforce customary law of nations rather than the U.S. statute. So the court really looked at the types of claims that were being put forth by the plaintiffs and saw that if universally condemned conduct like torture is not, so it went a little further there than we expected it to, but that was one of the reasons why it said that this claim was not precluded by Kiobel. It also said that it does not require the hailing of foreign nationals into U.S. courts to answer for their conduct abroad, because CACI is a U.S.-based corporation. It was expected that they could be held responsible for any tortious conduct by their own courts. And then finally, this was also, I think, a great point made, and surprisingly so, that the political branches of our government have already indicated that they will not accept any torture. So through the TVPA, as well as other statements that have been made, we pointed out statements specifically made with respect to the Abu Ghraib torture scandal, but the court did not limit it to those statements, saying that, this isn't actually affecting, like, the U.S.'s foreign relations, because the U.S. has already clearly stated that it will not accept torture, particularly by the acts of its own, conduct of its own citizens. So, Schonbrun presented a great case, but the court was sure to leave open that it's not the only case that can survive Kiobel. And I think, the Chowdhury case, which is a Second Circuit case that Kathy had referred to, which was against an individual, and they allowed the TVPA claims to go forward, but not the ETS claims to go forward, was because that was very much a foreign case. Even though the individual defendant was a resident of the United States, had gone back to Bangladesh where the tort had occurred several years earlier and had been in Bangladesh the entire time of the tort, so there wasn't a connection back to the U.S. And so what's interesting about that case is that was handed down after Valentulo, where Cabranes made a decision that Kiobel is sort of this black letter, this sort of strict, what am I looking for? This strict rule, I'm sorry, I'm on the left.
Bright line.
Yeah, bright line rule, that's it, thank you. But then Judge Pooler's concurrence in Chowdhury versus Wormtail showed that actually in the Second Circuit there still is this open question that there could be facts when you look at the focus of the ATS that allow claims to move forward, that I actually think would allow the Second Circuit to go more closely towards where the Fourth Circuit has gone.
Thanks. So we were supposed to end 5 minutes ago. I believe the next panel in this room starts at 3. So what I would like to suggest, because I do want to give the audience a chance to ask questions, we have some hands. I'll take a few questions at once, and then I'll give each of the panelists I regret to say 2 minutes, to just make some wrap-up remarks, and I'm sure we could, if we had time, discuss this for many more hours. And maybe some of you can continue the discussion in the hallways afterwards. Questions from the audience? Yeah.
My question is specifically from Myles, and the seeming endorsement of treaty law and the UN treaty-making process as the way forward in terms of this sort of thing. And I was wondering if you could comment on the recent move by the Human Rights Council to endorse the push for a treaty for corporate accountability of human rights violations, and how what the view on that?
I haven't followed that very closely, so I don't think I'm in a position to give you a very good answer. I'm not up to speed on the latest status of that. I just was offering that avenue as one possible model. Obviously since Ruggi's report, I know it sounds like you're pretty familiar with the path of this set of issues, and he issued, I think, at least 2 major reports, maybe more, kind of advancing the ball on corporate accountability. And, I've seen just in my practice an incredible push toward it in the last, say, 10 years, is companies enacting codes of conduct, putting them into place. That's what he was endorsing as well. He said there was no consensus on corporate liability. For a whole bunch of reasons, but mainly other nations don't do it, and other nations don't. But that's a whole, obviously that's the subject of a zillion briefs in the first round of Kiobel, so you can spend a whole day on that. But that was his conclusion anyway. And then he said the way to go is to instill in corporations principles of corporate accountability. So I'm not familiar with the status I don't know what the status is of that initiative. But I will say that is what the ILO structure is all about, is that they say that they have a sort of tripartite way of coming at things. One is the nations, the other is the employees, and the other is the employers. And each plays a role in moving human rights and in the labor arena forward. And the corporate role is to push, to show that they have an incentive to incentivize them to become aware of labor practices around them, to know what is going on, and then to show that they're respectful and they're doing something about it. Most mainly in their own, not to hold them liable for it, not to make them responsible to make sure that nations enforce their labor laws, but to do what they can. So,
I'm sorry to interrupt.
No,
I think that we're standing up to leave, and I hear people in the hall. Let's just give 1 minute to Kathy and Jeena also to make a final moment, and then I know people are starting to leave, so we're just 1 minute each.
Sure. This has been wonderful. I'm thrilled that I'm on this panel with these amazing people. I think that, I guess, am I speaking to this question?
Well, I thought we were sort of more than one question.
That, corporations are big, powerful collectivities, similar to states, but not states, and how the international community is going to figure out how to regulate these entities, which are often more powerful than the states in which they operate. So it's a huge challenge. The ATS has been one tool, and whether it will continue to be is something we're going to continue to sort of struggle over. But hopefully, I think a treaty regime will ultimately be necessary.
Okay, and last, any thoughts on the question?
I guess, well, on that point, I would actually refer them to, I think it was your article where you talk about historically how corporations were actually used as extensions of the state, and I don't really think that's a historical point. So I think it's a good thing to be thinking about when we think about the power that corporations have and whether or not they should be responsible for ensuring that human rights at those surrounding them.
I'm sorry to cut off such a fabulous discussion, but I'm sure you all will enjoy the next panel as well. Thanks again to our panelists for such